Thank you very much, and good evening, ladies and gentlemen. There's a very famous saying, and given the hour and the time of the week, I think it's good to lighten the mood. There are only two types of people in this world, Italians and those who want to be. Thankfully, I'm a member of the first. I also love coffee, but also, thank God, I'm not a member of the left. Okay, so what are we going to talk about today, or this evening? Now, I wanted to have a look at the American Supreme Court's approach to applying rights under the First Amendment to the Constitution, and the Australian High Court applying the implied right of freedom to political communication. There was the American case of McCullough and Coakley, and Clubb and Edwards are both cases dealing with abortion and buffer zones. Okay, now, in my view, and I know there are speakers today who might have expressed a different view, including those who are very closely associated with arguing the case for the High Court. In my view, I think the approaches under the First Amendment to the Constitution, the jurisprudence surrounding that, and that surrounding the implied right to freedom of political communication are actually quite similar. But we ended up getting a different outcome here in Australia. And if indeed the implied right is far narrower than the First Amendment rights, I think that this will have far wider implications for political communication than many have so far realised. Now, I want to quote from a novel by Hans-Peter Richter. It's a novel, Friedrich. Some of you may be aware of it. It was published in German in 1961. And I'm not a German speaker, but I think you could pronounce it as Damals war es Friedrich. And it's a novel about two boys and their families as they grow together during Hitler's rise to power and his rule. And actually ends in 1944. We actually studied this novel at school. Some of you might be familiar with it. Now, it was actually, and because I'm a translator, I'm interested in when this novel was translated, and it was translated in 1971 by the very accomplished translator Edith Kroll. And I want to read some excerpts from chapter 12, the hearing. And Friedrich Schneider and his family are facing eviction from their apartment because they are Jews. And it's quite telling on the role of the courts. Now, people earlier today have spoken about legislation and the fallacies of legislation, and we can legislate till the cows come home. But at the end of the day, when we have a bad law, there's only, in our system of the separation of powers, there's only one institution we can turn to, and that's the courts. And I think this chapter actually bears this out. So, Herr Resch, who's the landlord who is defending his idea that he wants to evict the Schneiders because they're Jews. And the judge questions him. He calls him and he says, well, Herr Resch, up until yesterday, before this law was passed, you had no issue with the Schneiders being in your apartment because they were Jews. Herr Resch stepped closer to the judge's table. Yes, but it was different then. Times have changed. Now I cannot tolerate a Jew in my house. The judge waved this aside and said to Herr Resch, since you became a member of the NSDAP, you cannot tolerate a Jew in your house. Can you assure me in the near future that you may not join a party which is against Catholics or vegetarians? If I accede to your claim today, you may stand before me in a year or two and demand a verdict against another tenant because he is a Catholic or doesn't eat meat. Herr Resch shook his head. Oh, but that's something quite different. So in the end, Herr Resch is actually persuaded when he sees the judge. This is actually set in 1933, by the way. Hitler's just come to power and the laws have just been passed. Herr Resch says to his barrister, look, it's all going to be too hard. So Herr Resch's barrister stands up and says, Your Honour, my client has empowered me to retract his claim and he will bear the costs. So the judge closes the folder. And Friedrich, the little boy, all at once cries out. He's just been sitting there next to his mother this whole time in fear. And all of a sudden he cries out. And his mum, Frau Schneider, as the novelist recounts, put her hand over his mouth. Who was that? The judge asked. My son, Herr Schneider. The judge called out, "Come up here, my boy." Herr Schneider collected Friedrich and led him to the judge's table. Friedrich was still crying. The judge then questions Friedrich. "Why are you still crying?" The judge asked warmly, "You don't have to worry. Nothing will happen to you. That's why I'm here, to see that justice is done." Friedrich wiped his eyes, looked at the judge and said, "Yes, you." Let's have a look on that note to judges actually applying the law. The American approach, I think, to the First Amendment as far as abortion buffer zones is concerned was outlined in McCullen and Coakley, which is a 2014 decision. There's the First Amendment, straight out of the Bill of Rights, the American Constitution. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people to peaceably assemble and to petition the government for redress of grievances. Just an outline of some of the jurisprudence surrounding the First Amendment. So what this means is that government has no power to restrict expression because of its message, its ideas, its subject matter, or its content is to be applied with full force to footpaths and public streets. So the government cannot prevent or prefer speech because of its content. And this was outlined in the Police Department of Chicago and Moseley, and in 1983 in the United States and Grace. And if you can't see the picture, the lady in the picture is holding up a sign outside what appears to be the Supreme Court building saying, "Protects free speech." And the policeman replies, "Ma'am, notwithstanding the irony, you're not allowed to protect free speech on this side of the street." And that's because there was a law that was designed to stop people protesting on the steps of the Supreme Court. And that was held to be contrary to the First Amendment. However, the government may impose reasonable restrictions, and I'm quoting here, on time, place, or manner of protected speech, provided that the restrictions are justified without reference to the content of the regulated speech, that they are narrowly tailored to serve a significant government interest, keep that in mind, so long as they leave open ample alternative channels for communication of the information. So, this means that restrictions must not burden, and I quote, substantially more speech than is necessary to further the government's legitimate interests. Hold that thought. And that was outlined in Nozhnik and the City of Jacksonville. And finally, in relation to the First Amendment is concerned, if the restrictions on the law aren't actually based on the content of the speech, they were content neutral, even then they would only be constitutionally valid if they could withstand strict scrutiny. In other words, the law has to find a least restrictive means of achieving a compelling state interest, and that was outlined in Ward and Rocco against racism. And for those of you who can't see the picture there, that was a law against prohibiting a certain level of music in Central Park in New York. The anti-racism protests were playing very loud music, so the City of New York tried to impose a law saying, look, keep the volume down, and that was held to be contrary to First Amendment rights. So, let's move to McCullen and Coakley. This was a 35-foot, and for those of us who were born after 1974, some people ask me, what's metres in inches and feet? I say, I don't care. I was born in 1976. Australia moved to metric in 1974. But that's 35 foot, 10.67 metres. Not much, eh? Exclusion zone outside an abortion facility in Massachusetts. This law made a crime to knowingly stand on a public way or sidewalk. Councillors have footpaths in Australia, and I defer to, I realise we have American friends here, so apologies. Councillors provided women with information about their alternatives to abortion and help any of those in taking any of those alternatives if they wish to. And so the lady here hands a leaflet to a couple seeking to approach an abortion facility. The troopers come and say, you can't do that, that's breaching the law. So she challenges the validity of this law on the basis that it violated her First Amendment rights. And interestingly enough, her evidence was uncontradicted. that prior to this time, 2007, about 100 women had chosen alternatives to abortion as a consequence of her actually handing these leaflets and counselling people outside, but none since. And Professor Quinlan, from his article on the case. Unanimously, the Supreme Court, although the views differed, found that this law violated the First Amendment. Just picking out the plurality judgment of Chief Justice Roberts and then Justices Ginsburg, Breyer, Sotomayor and Kagan, the law wasn't content-based, so therefore wasn't subject to strict scrutiny. However, the court found that it burdened substantially more speech than was necessary to further the government's legitimate interests. Yes, there was a legitimate interest in attempting to prevent deliberate obstruction of clinic entrances and harassment of patients and staff. However, these concerns were already addressed in other sections of that particular piece of legislation, which prohibited obstruction, blocking or hindering entry to a reproductive healthcare facility, as well as under the general criminal law. Assault, trespass, breach of the peace, you name it. The tools are already there. So this law burdened more speech than was necessary to further the government's legitimate interests because it excluded all persons other than clinic workers from the exclusion zone. So, in the words of the Supreme Court, it swept in innocent individuals and their speech. So it made it more difficult for those such as counsellors to engage in conversations at normal proximity and volume and to hand out leaflets. The law said a better way would have been to have targeted injunctive relief at precise conduct and against precise individuals, and if you did that, then the Constitution, and in particular the First Amendment, wouldn't be breached. Now, Antonin Scalia and Justice Alito went a step further, and they argued the law should have been subject to strict scrutiny since it targeted abortion and, of course, therefore, had to be content-based. Again, hold that thought when we come to discuss, or when I come to talk about the various judgments in Clubb and Edwards and Preston and Avery, which is what I'm going to do right now. Now, just a little bit of a history lesson. Now, on the face of it, I think the argument, it's a quite safe argument to say that there's no equivalent to the First Amendment in the Australian Constitution because we don't have a Bill of Rights. Various state constitutions have provisions guaranteeing freedom of thought and conscience, and in particular Section 46 of the Tasmanian Constitution, which guarantees freedom of conscience and freedom of religion and may allow protesters to raise such issues in their defence in future prosecutions. However, in Clubb and Preston, this wasn't seen as enough. Now, in Australia, as I'm sure you're aware, we've spoken about it earlier today, we have 150-metre exclusion zones in various states. Now, we need to look at the implied freedom, which I know has been alluded to today, and others haven't gone into the nuts and bolts. And I realise on a Saturday night it might be a bit difficult, but I'll do my best to try and synthesise what is indeed a very complex argument. Now, Longy and the ABC, it's a reaffirmation of the implied right of freedom of political communication in the Australian Constitution, which was first recognised in Australian Capital Television and the Commonwealth and Nationwide News. Now, this is actually a negative right. It's not a grant of a freestanding positive right, and it operates chiefly as a restraint on executive and legislative power to the extent that such power would burden the implied freedom. Now, how does this doctrine work? Well, as the High Court explained in Logie, he's actually German heritage, and the pronunciation of his name is actually Langer. But obviously, down the generations, it ended up being easier to say it, Longy. Now, this general doctrine actually turns on the answer to two questions. So, does the challenge law burden communication of the relevant kind? And if so, secondly, whether the imposed burden is reasonably appropriate and adapted to achieving the legitimate end. And as was discussed in McCloy, New South Wales, this is applied through a proportionality analysis on whether the law is A, suitable, is there a rational connection to the purpose of the provision, B, necessary, there's no obvious and compelling alternative to achieve the same purpose, which has less restrictive effect on the freedom, C, adequate in its balance. There has to be a balance between the importance of the purpose served by the restriction and the extent such restriction imposes on the freedom. So I think you can see where I'm getting at here. Turning to Preston and Club. The two acts, one in Victoria, the Public Health and Wellbeing Act of 2008, Section 185D, prohibits a person from engaging in prohibited behaviour within a safe access zone of 150 metres. And prohibited behaviour under that Act includes communicating by any means in relation to abortions in a manner that is likely to be seen or heard by a person accessing, attempting to access, or leaving premises at which abortions are provided, and it's reasonably likely to cause distress or anxiety. Under Section 9.1 of the Tasmanian Act, prohibited behaviour within 150 metres of the access zone is defined to cover a protest in relation to terminations that is able to be seen or heard by a person accessing or attempting to access premises at which terminations are provided. Significantly enough, protest is not defined. And as we've seen in a lot of laws that have been under discussion today, definitions are absent. What were the relevant facts? Cathy Clubb, just like in McCullen and Coakley, handed a leaflet to a young woman approaching the facility. Preston in Tasmania was holding up signs which spoke about the rights of the unborn child under international covenants. Both were charged under the state laws which I've just mentioned, and they wished to challenge this on the basis that it breached the implied right to freedom of political communication in the Australian Constitution. Now, the High Court held that Cathy Clubb didn't actually engage in political communication since she shared a leaflet with another. Therefore, there was no need to, she had no reason to argue that the implied freedom applied to her, so her conviction was upheld. Preston was considered to have engaged in political communication, but the High Court reasoned that even though the law was a burden on political speech, the purpose was legitimate, acceptable, appropriate and adapted to the circumstances. So what is political communication? Well, even by dissuading a couple from proceeding with an abortion and offering alternatives, I would have thought, and this is actually the subject of legislation. And if something's a subject of legislation, it has to be political. It has to be. And in a representative democracy, in order to change the law, you have to have discussion and debate. So, even as Morris and Stone said in their article in the Sydney Law Review, this has to be considered political communication about government or political terms in terms of the Longing test. So if governments are going to legislate, and if, as Josh very eloquently pointed out, in between state, federal and territory, you've got plenary powers to legislate on just about anything. If we're going to talk about that legislation in whatever way we choose, it has to be political communication. So I would have thought, in my humble view, that this is similar to a content-based approach to the First Amendment. And the High Court has continually held that on-site protest activity constitutes political communication. Laurie Levy and Victoria and Brown and Tasmania are recent cases in the High Court on that. Now, further comment on laws regarding abortion with a view to supporting laws and policies that would restrict access to abortion, as Morris and Stone argue. would be a political act of demonstration that could influence electoral decision making. Okay, so if you're going to make an argument that the law should be changed, it has to be political communication. Now, as we saw, Preston was held to be political communication, but the first limb of Longy was satisfied, but it was appropriate and adapted. So let's look at this. Was the law reasonably appropriate and adapted to serve a legitimate end, the fulfilment of which is compatible with the maintenance of constitutionally prescribed system of representative and responsible government? That's the test as outlined in Longy. So it has to be suitable, necessary and adapted. Now, I think, as Foster points out, that this would be similar to a First Amendment approach, that a law can't impose restrictions on the time, place or manner of protected speech, provided that the restrictions are justified without reference to the content of the regulated speech and that they're narrowly tailored to serve a significant government interest. So I think that this is the same, but it's different. Okay? And I think it leads to an inconsistent result because the approaches in terms of the jurisprudence, I think, are actually quite similar. The facts are on all fours, as we say in the law. It's very similar to McCullen, counselling, handing out leaflets. And the judges in the High Court did point out that, yes, there was a much smaller exclusion zone here. And in fact, Justice Edelman did point out that if this law was enacted in America, it would be held unconstitutional. But as pointed out in Clubb and Preston, there were alternatives in both the legislation and under the general law that would have prohibited, that would have included legitimate prohibitions that would have served the legitimate interests, because there are already prohibitions in both the Tasmanian and the Victorian legislation regarding besetting, harassing, intimidating, interfering with, threatening and hindering, obstructing or impeding. And that's straight out of Morris Stone's article, and not to mention the general law under assault, etc. So what are the implications? And I hope I can indulge you for a couple of extra minutes here. Okay. Now, Justice Gageler was the one who came closest to, in Clubb and Preston, saying this law should be held as breaching the implied freedom of communication. In the end, he didn't, but he said the implications of, if we continue down this path, I think, are that such laws would apply to curtail protests by those who seek to express disapproval only. And such laws would require a high level of scrutiny, as Antonin Scalia said in McCullen. And a law would be valid only if it has the purpose of dealing with an offence. Okay? And you could have laws that would legitimise pro-choice but not pro-life activity. Okay? What else would such a law, what might be the unintended consequences? Prohibition of picket lines. Prohibition against protesters, against logging. I think these are things that have not been thought through. And if we're going to be consistent, why don't we prohibit protests outside churches relating to child abuse accusations? If we're going to be consistent. Surely all of these would also be the subject of political communication, because there's legislation on it. And governments in this country have, as we've seen, plenary powers to legislate on whatever they choose, provided it's for the peace, order and good government of the country.